Hey folks, Eric from Another Voice with Jason and Eric with you today. We'll talk about the Supreme Court and Obamacare. As you know, the Supreme Court heard oral arguments over whether or not the Patient Protection and Affordable Care Act was constitutional. 26 states have sued the federal government to stop it. There have been various decisions, various aspects of it that they believe are wrong. There was 3 days of arguments beginning on Monday, and they focused on 4 separate aspects or concerns that the lower courts had addressed. It was heard by a number of lower courts. I'm thinking like 10, 12, and there were like 5 or 6 on each side. The first day, Monday, was almost a day that could have ended all of this for at least another 2 years. And that was the lower court, the Federal Appeals Court in Virginia, had ruled that the penalty for failing to get insurance coverage with the individual mandate, the penalty was a tax. And as a tax, fell subject to the Anti-Injunction Act of 1867. Which basically says you can't sue for a tax to stop a tax until after you've actually paid the tax. Now, if the lower court ruled that it was a tax, and therefore this case shouldn't be before the Supreme Court until approximately 2015, because the individual mandate doesn't go into place until 2014, and then the first people who would be charged with a penalty would not be until 2015. Neither parties in this case, the 26 states nor the administration, agreed with that ruling. And they believed it was a fee, and therefore you could decide this case now. So the court had to appoint an attorney to argue the lower court's case. Now it's basically a moot point. The basic argument was the language of the law called it a fee, and therefore it's a fee. But it looked, smelled, and acted like a tax. It was an IRS tax code, so it could go either way. But the basic fundamental idea is it's probably, that's a moot point. They're probably not going to make that, and the questioning from the justices seemed to indicate that they weren't going to lean in that direction. The big day, the most important day, was Tuesday, and that's when the individual mandate itself was discussed. The federal government maintains that Congress has the right to require every American to purchase health insurance under the Commerce Clause, where the federal government has the right to regulate interstate commerce and also under the right to levy taxes. The 26 states say that's an overstepping of the bounds of the federal government. They state that you're requiring people to participate in commerce in order to regulate the commerce, which was one of the questions that the justices asked about, are you creating a need for the commerce in order to regulate it? And if you, like most of the talking heads who talked about what was going on, you look at the questioning from the justices, and you got what they believe to be a fair idea of where the sentiment is. The 4 liberal-leaning judges tended to ask questions that seemed to indicate they supported the individual mandate. The 4 conservative-leaning justices seem to be asking questions that would say they disagreed. And then Justice Kennedy, who goes back and forth, seemed to be on the side of the conservatives. So if you just take what the questions were and how they were asked, you could maybe indicate that the Supreme Court was leaning toward shooting down the individual mandate. We'll have to wait and see. Day 3 brought another very important thing. If the individual mandate is considered unconstitutional, what do you do with the rest of the law? The 26 states' position is that if the individual mandate is unconstitutional, the whole law must be scrapped. The administration's position is that if the individual mandate is scrapped, then the only 2 other aspects would need to be scrapped. One would be requiring insurance companies to cover pre-existing conditions, and the other being requiring insurance companies, not letting insurance companies, let me try this again. Insurance companies can't refuse anybody. That would have to go because of the individual mandate. The federal appeals courts in Richmond and in Washington both said that you could get rid of the individual mandate, but keep everything else. So there were three basic positions on that, and the court had to get an attorney to argue the appeals court's positions. Now that was a little more interesting, a little less clear as to where the justices were going to fall down on that and where they were going to do it. It's not, from their questionings, it's not a guarantee that they would throw the whole thing out. And then later on, they talked about the Medicare, expanding of Medicare. Was that a violation of the federal rules? So we'll have to wait until June to decide what's going on with the Supreme Court. When they get ready to close the session, they're going to announce their decision. They've been debating in secrecy, or in private, I like to call it, and we'll wait and see. It is going to be a huge campaign issue during the fall election. So stay tuned. We'll see if we get any more information coming out. And don't forget to tune in Mondays to WOLT 103.3 at 1 p.m. to hear another voice with Jason and Eric.